So, if your brand name is infringed or misused, what would you do? What powers you have? What cases you can file? So, we'll talk about this today. So, in case when your trademark has been infringed or it is misused, in this case, if you wish to explore the option of an amicable settlement or amicable resolution before taking any legal action, then you may choose to send a notice called cease and desist notice. So this notice has to be sent to the violator. In the notice, you should inform the violator about your prior trademark rights. You have to inform the violator that you already have trademark rights of this particular mark or logo or brand name, and you have to highlight the violator's illegal and objectionable activities, and then you can list out your demands for compliance within a set timeline. So the first step can be this: you can try for the amicable settlement. But in case there is no amicable settlement or there is no resolution, then a legal notice has to be served upon the violator. Now, when the legal notice is served and then also there is no settlement, then comes a stage where you have to decide that you fit under which category, and you have to file which suit you can file basically. So the first option is you can go for the suit for infringement. The suit for infringement can be filed against violator. This case can only be filed if you have a registered trademark. So it is important that you should have a registered trademark. But there can be situation where there is no registered trademark. The trademark is not registered. So in that case, what will you do? In that case, you can go for the suit for passing off. So suit for passing off will be filed if it is unregistered trademark. Passing off means that a third party is trying to pass off or it's trying to misrepresent its goods and products as belongings to the original proprietor by misusing the latter's trademark. So this is what passing off means. So in order to make a case of passing off, it is important that the plaintiff has to satisfy a 3-layer test to the court. This test is called as Trinity Test. So in order to make a case, in order to establish a case by the plaintiff under passing off, it is important that the plaintiff have to give evidence, have to satisfy 3 things to the court. The first one is goodwill of the trademark through qualitative evidence of use. So we have to prove this at first place. The second one is misrepresentation on the part of the violator. And the third thing is likelihood of any damage. So because obviously if there is no damage, if there is no loss to you, then obviously why would court grant you any compensation or damages or any such thing? Why would court recover your losses? So it is important to show to the court that there is a likelihood of damage. So these 3 things has to be proved, has to be established while you are doing a suit under the passing off head. So with registration of a trademark, obviously it is very easy to secure interim or temporary injunctions, or it is very easy to take a stay. But obviously when you don't have the registration of the trademark, then obviously the hardships will come. So you will have to face the hardships. Apart from the suit for infringement or the suit of passing off, you can go for suit for temporary and permanent injunction. So this suit can also be filed immediately to take a stay on the illegal activities going around, and then take a permanent injunction, take a permanent stay after a proper trial. So these things can be done. So apart from the civil remedies, there are also criminal remedies. In case of trademark infringement, one can process with a criminal case also, because infringement of trademark or misusing of trademark is considered to be a criminal activity also. So a violator can face hefty fine, hefty penalties, even imprisonment can be there, which can be minimum of 6 months and maximum of 3 years. So apart from civil remedies, there are criminal remedies also available. Apart from that, there is a cancellation action that also can be taken on the violator. In the event if the violator has a similar trademark as yours, you can initiate for the cancellation against such registration. So this remedy can only be taken when you have registered trademark and someone has adopted similar or identical trademark as of yours. So apart from this, what all you can claim while you are suing the other party. Number 1, you can claim damages and compensation from the violator. Number 2, you can recover your losses, whatever losses you have faced or suffered, you can recover the losses subject to proof or evidence. You have to prove, you have to give the entire bifurcation to the court that these are the heads where you have suffered losses, so you can recover your losses if any. The third thing, we can also ask to immediate seize the misuse of the trademark. So that can be done in temporary and permanent injunction case. The fourth thing we can ask is to immediately remove all posts, all banners, everything on social media, flyers, hoardings, etc., if there is any which uses the mark. The fifth is we can also ask the violator to reveal the name of other entities who are engaged with you. So this can also be done. And the last thing we can ask for, we can get a particular undertaking or an agreement or memorandum of understanding done and signed by the violator to avoid future misuse. So all these things can be done if your trademark is infringed. Thank you.